I've got quite a bit to cover here in quite a short time, so I'm going to jump right into it. I want to talk first about our program at Ohio State. I have the Ag and Resource Law program. You can find our information on the Farm Office website that I share with Barry Ward, and that's farmoffice.osu.edu. I write a lot about ag nutrient issues especially, and so you can sign up there for my blog and receive articles if you want to be updated on what's going on legally on some of these agricultural issues. And this is me. I did this because Glenn told me to do this, and when Glenn tells me to do something, where did he go? He said we had to put our picture in our presentation, so there it is. You obviously all know that's me, but there, Glenn, I did whatever you told me to do. Okay, moving on. Well, maybe. There we go. So I want to tell you a little bit about some things that have been happening at the federal level that concern me for what we have going on here in Ohio, some issues related to agricultural nutrients, a lot of concern, of course, with manure as an ag nutrient that may need to be further regulated because of water quality impacts. And those concerns started building about almost 10 years ago at the federal level when they started talking about the impact that agriculture has on water quality, and specifically the impacts that ag nutrients have on water quality. So there's been a lot of task force type analysis going on at that federal level, trying to determine what to do in regards to agricultural nutrients from that federal policy perspective. And at the same time then, we've also seen litigation, and this usually occurs when environmental or other types of interests are not happy with policy and legislative efforts to address an environmental issue. And so one of their typical strategies is to utilize litigation directly against those who they believe are creating the environmental problem. And so we've seen a lot of litigation around the country against some of our big operations, and a lot of that would be coming out of the Clean Water Act, which is our NPDES permitting structure that oversees those larger CAFOs. And so a lot of litigation there challenging permits. That's been a traditional approach. But over time, they're starting to use other federal laws like RCRA, the Resource Conservation and Recovery Act, the Safe Drinking Water Act. That's entirely new in the last few years, to use that in an agricultural situation. And then also trying to broaden the Clean Water Act and how it can be used to address manure issues. So a lot going on. I want to tell you about the big one. Some of you may have heard me talk about this one. I can't preach enough about how important this case is. This is the Care versus Cow Palace case, big dairy out in the state of Washington. State of Washington, I should say, does not have the kind of state program that we have here in Ohio, not nearly as good as our livestock environmental permitting program. So there's a lot of issues just with the state agency and their ability to regulate manure from livestock operations, but there were a lot of problems with the operation as well. And so a group formed to bring a lawsuit against the dairy in regards to manure pollution, and they used the federal law that I just mentioned, RCRA. And this is not a law that has been easy to use in agricultural settings. This law is governing the disposal of solid and hazardous waste, and there's an exemption in this law for agriculture, and it says that RCRA does not apply to agricultural wastes, including manures and crop residues that are returned to the soil as fertilizers or conditioners. So there's a reason I underlined that last phrase, return to the soil as fertilizers or conditioners. So as long as you're in that situation, then this federal law will not apply to you, and it cannot be used to address a manure issue. But the question in Cow Palace was that manure actually being returned to the soil, or was it not being utilized? And they claimed that it wasn't being utilized. It was just open dumping of solid waste. There was no clear plan and no management practices to back up a plan to return that manure to the soil as a soil conditioner. So they were able to effectively argue their way around that agricultural exception in RCRA, and claimed that these people are not, this is not beneficial reuse of the manure. This is open dumping. This is discarding waste, discarding manure, and it is leaching into, and indeed they had the data to suggest that it was leaching into nearby water wells and polluting water in that area. So remember, I said that they did not have good management practices at this operation, and so that certainly became a problem. The court agreed with the plaintiffs in this case and said, we agree with you, this is not beneficial reuse of manure, this is open dumping. This is discarding in violation of RCRA, which would mean then that they would have to come under the requirements of RCRA. So they really took issue with over-application of manure. That was the judge's biggest concern in this situation, that they had a nutrient management plan, they weren't following that nutrient management plan, and they, excuse me, in that nutrient management plan had not accounted for residuals. So a lot of digging into the actual plan that occurred here by the court, not something that makes me entirely comfortable to think about a judge analyzing a nutrient management plan and trying to determine whether it was a good plan and whether it was followed, but that's exactly what happened here. And so over-application led to excess and not beneficial reuse of the manure. And then the judge also took issue with the lagoon storage and the compost area, both which allowed permeation. I'm not going to focus as much on those as on the application. So what happened at the end of this case, the judge said, yeah, there's no doubt in my mind that we've got pollution going on here. We've got an imminent and substantial endangerment to the public. We've got open dumping of hazardous waste, and it was all, again, the manure from that facility. So they ended up settling this case. The dairy agreed to further manure application restrictions, as well as all these other practices they had to put in place. Spent a lot of money putting in new liners and groundwater monitoring systems and concrete aprons. They had to replace water for a lot of the people in the community, and they still are doing that. They're still providing water and reverse osmosis systems for those who live in that area. They had to fund a clean drinking water project that would address some of the implications of that pollution. And they had, in attorney fees alone, over $300 and some thousand that they had to pay for the other side's attorney fees. This was a very costly situation, and I ask Kevin a lot, we don't have this kind of an operation in Ohio that might see this kind of lawsuit, do we? We don't want that kind of an operator that would make this strategy so easy now that we have precedent. So if there's a situation where an operation is not using and applying that manure to the benefit of the soil and is actually over-applying, this kind of a federal lawsuit is very much a possibility. So we have to be very careful about that here in Ohio, and I hope we don't have any facilities that are suspect to this kind of litigation. It was a pretty creative strategy that they used, and this is a trend that I've been able to track around the country now. What we're seeing is they actually begin with a Safe Drinking Water Act petition. This is not something that we have seen used against agricultural operations, because most people think of this federal law as pertaining only to public water supply systems, And it does, but there's also some language in there that says, or any underground water supply. So if there is a threat to either a public water system or an underground water supply by way of pollution, then someone can file a petition under the Safe Drinking Water Act and ask the U.S. EPA to come in and investigate that situation. Now, one of the requirements is that the state is not adequately addressing the issue, and the second is that there's a substantial and imminent threat of harm to that water supply. Well, in this case, the plaintiffs first filed this Safe Drinking Water Act petition, and what happens then is EPA, the U.S. EPA, has to go in and investigate the situation. So basically, they had EPA do all the work for them. The U.S. EPA went in and gathered all this data to determine what was happening on this dairy, whether there was a pollution issue, whether there was an application problem, and generated this whole record that then the plaintiffs were able to pick up and use when they filed their lawsuit against the dairy. So it's pretty, I applaud them. It's smart. It's a smart use of the federal tools that are available, and it had never been done before. We're starting to see these cases, these Safe Drinking Water Act petitions pop up around the country. Here's the requirements: substantial threat to public health, and state or local officials have not taken adequate action to protect health. That's what you need to be able to allege when you file the petition. And as I said, we're starting to see a number of those. This is one that was filed up in Wisconsin, and this investigation is still going on. There are quite a few investigations up in Wisconsin going on under the Safe Drinking Water Act. We have not seen any here in Ohio, but I think when this happens, we can assume that it's a precursor to a federal lawsuit, that they're, as I said, kind of forcing the U.S. EPA to gather all the data, and then they're going to use that to file a federal lawsuit. So we've got to keep an eye on that here in Ohio. So let's talk more about manure liability under Ohio law. Federal law is one way that you can be liable, either by violating your permit, or now we know under RCRA. The permit would be under the Clean Water Act or under RCRA with this approach that occurred out in Washington. But when we look at Ohio law, of course, we have the permit violations that can occur for our permitted facilities. But I want to look more closely at the Ag Pollution Abatement Program. That's the one that is worded so interestingly in our law, that you must comply voluntarily with orders of the chief to abate agricultural pollution. So we have that one, and we also have, and that's administered, as you know, by ODA through our soil and water conservation districts. The Ohio Water Pollution Control Act and the Ohio Stream Litter Act both have provisions in them that would allow the Ohio EPA to enter into a pollution incident if there's been pollution of a water in Ohio. And then we also have our wildlife takings laws. There are a couple of those that prohibit the taking of wildlife by way of pollution, and that can bring ODNR into an investigation situation. And that's what we saw recently with a few incidents where manure got into the waterway, I guess not too far from here. We had some incidents, and all three of those agencies in that situation have the ability, the authority to investigate that manure pollution situation under these various laws that we utilize here in Ohio. So if there is an incident of manure getting into that waterway, liability can range from civil fines to criminal fines. Jail time, you don't see that very often, but these are criminal misdemeanor charges that can arise under the different laws that I just presented. There are remediation costs that can be assessed back upon the party who created the pollution incident, as well as recouping for the cost of the investigation. That can also be a cost assessed back to that party. And then we often see, certainly in water situations where there's been a fish kill, the payment of the minimum value of those animals that were lost because of that pollution incident. So these can be costly problems or mistakes that occur under those various laws that lead to liability. So a question that I often receive, though, is who exactly is liable? Is it the landowner where that pollution incident occurred, or is it the applicator who applied the manure? Maybe that was a custom applicator. Is it the farmer who was renting the land, who hired the applicator? This starts to kind of sound like a children's nursery rhyme or a book after a while. Is it the livestock operator who supplied the manure? Or maybe there was an employee involved in the situation and the employee made a mistake that led to the manure incident. So who might be liable? And those of you who've heard me speak before would know I'd say, well, we can probably bring them all into this and try to make them all liable, let them fight it out as to who financially is responsible for that manure liability situation. But in most cases, it's likely that, the person who actually applied the manure. But we have to first look to the statute that's going to help us decide who might be liable. Well, which statute are we going to bring this liability incident under? Because the statutes use different words. No person shall do this, or there shall not be this incident. So some of them will allocate personal liability pretty clearly, and some will say, to make it sound like it's more like where the incident occurred, the land. So we have to look to the statute and see what that wording might be. And we also have to look at the relationship between these parties. If you're using a custom applicator and you're using a contract, that contract, if it's a well-written contract, will shift the liability to the custom applicator. That's a provision I would put in a contract to make sure that, okay, I'm the person who hired you, but I'm shifting it all over to you because you're the person in control of this manure. So we need to look to that arrangement. Is there some kind of contract in place? And if not, then what has been the course of dealing between those parties? And did the farmer who applied the manure, that's easy, but if the farmer hired someone else to apply it, did that farmer have anything to do with that application? Did that farmer try to control and manage that application? We'd have to look into those things to know whether that farmer could also be liable for the situation. And the same with the landowner. If that's a third party involved in that situation, there could be a lease in place that would address manure applications. That's a common provision that we're starting to see in some of our farm leases. So we'd have to investigate all of that. That's why it's hard to give an answer to some of these, to know ultimately who will pay the final price of that pollution incident. And then, of course, the facts become really important. What actually happened, what caused that manure pollution incident, that's going to be important too. So I don't have an easy answer for this question, who is usually liable. I think in the end it tends to be the applicator that will be the easiest case to prove, and then beyond that there could be some battles between the applicator and the other parties that might shift some or all of that liability, but it's most likely the applicator. So then what happens if you do have a manure pollution incident? Well, we've seen some cases recently in other states that raise some concerns about insurance coverage. And if you go back to that Cow Palace case, the dairy out in Washington, you'll see that there was a case against the insurers fighting over whether that insurance coverage forced them to represent the dairy in that case. And they argued that no, there was an absolute pollution clause that said that if there's an incident of pollution, this policy does not cover that, and we do not have to indemnify you. We do not have to stand up and represent you legally. And so in that case, they were able to the insurer was able to prove that that manure, that over-application, because you put too much on, that became pollution, and we're going to use our pollution clause to get out of this. And they did. They ran away from that case as fast as they could. They said, we have no duty to defend, and we have no duty to cover you in this situation. And that was rather bold in that case. We've not seen an insurance provider be that bold about not defending their client. But now we've also seen in Minnesota, New York, and Iowa similar cases where the insurance company refuses to stand up and represent the operator because it looks too much like a pollution incident. And that can kick out your insurance and lose your coverage as well as your legal defense. So something to be aware of. I would encourage you all to take a look at your insurance policy. Excuse me. If you have a pollution rider, read it closely and understand what it's saying, what it will and will not define as pollution, because in that case there was a pollution type rider, but because of the over-application, they wouldn't even take a look at that. So be very careful about these provisions and understand what you're covered for if you've got manure on your property, and make sure your coverage is sound. And I think I'm probably out of time, Glenn? Good? Okay, so what questions can I answer for you? Yes?
If you substituted the term crop protection products or chemicals for manure, would you see similar legal responses?
Oh, sure. The attorneys would just love to get hold of that. His question is, if we replace the word manure with crop protection services, and I guess I should ask you, in what context are you talking? Just in a contract, or just generally, or?
Yeah, I think you might find some different chemicals in different waterways or drinking sources, and I'm just curious what might come.
So I don't think you don't get around the federal and state laws. Those are pretty clear as to, that manure cannot get into the waterway, period, regardless of what we call it. Under the insurance provision, I think we'd even have a problem there in trying to call it something else, or write specific coverage for crop, what did you call it? Crop protection, I can't even say it, services. I don't think that would work, no. I really don't see much credibility to that just by trying to rename the activity into something else. No. Kind of creative, but I don't think it would work.